A Kansas Transfer on Death Deed, or TOD for short, is a form that can be used to ensure that real estate is transferred directly to a successor following its owner's death. It provides a way to avoid probate for real estate. The actual transfer of ownership does not occur until the death of the owner. The owner can revoke the transfer on death deed at any time during his or her life. In this video, we'll cover the difference between a transfer on death deed and a will, legal requirements for recording a transfer on death deed in Kansas, and how to revoke a Kansas transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to help you navigate the legal world with confidence. To begin creating your own Kansas transfer on death deed, click the link at the end of this video. Let's start by talking about the purpose of a transfer on death deed. How is it any different than a last will and testament? The simple answer is this. Much like a will, a transfer on death deed can be used to pass property down to designated beneficiaries after your death. However, unlike a will, a transfer on death deed is exempt from probate. If you're unfamiliar with probate, it's the legal process of proving a will, paying a deceased individual's debts, and distributing the assets that remain. This process can be quite lengthy and stressful, which is why a transfer on death deed can be so valuable. Okay, but how do you complete a transfer on death deed? Completing a transfer on death deed in Kansas is pretty straightforward. The form will ask you for basic information like your name and the beneficiary's name. But one section that can be confusing is the legal description of the respective property. Unlike an address, the legal description delineates the tract's exact location using longitude and latitude, distances from landmarks, a block number, and other descriptors. If you're unsure of your property's legal description, check property tax statements or the current deed. The Register of Deeds should also have access to this information. So let's say you have completed the form. What's next? Kansas law requires that you get the document notarized. From there, you will need to take the document to the Register of Deeds in the county where the property is located. It's important to note that the transfer on death deed must be recorded before your death to be valid. If you record a Kansas transfer on death deed and later decide to revoke the deed, you can do so by one of two ways. Complete an instrument of revocation and get it notarized, or complete and acknowledge a new transfer on death deed. Each of these documents must be recorded with the Register of Deeds before the transfer's death to be valid. Click the link below to begin creating your own Kansas transfer on death deed, and don't forget to subscribe to our channel for more related content.